So I'm not sure. So it's live. There we go. Took a little while, y'all. Sorry about that. I am so sorry about that. Okay. Okay. All right, before we begin with the show, how is the volume? How good can y'all hear me on a scale of 1 to 10? I got a case I want to read to y'all too. It's about 6 pages. It's a real good case though. Real good case. Um, can y'all let me know how the volume is in the chat? Scale of 1 to 10. How good is it? 10. Okay, cool, cool. All right. Somebody asked me a while back. Um, there's this notation going around that if you file a motion in court, you are implicitly granting them jurisdiction. And I disagree with that. I say it's not true. And I'm going to show y'all the case that says that. Um, so what I'll do is I've been experimenting with this software all day. So hopefully I can get this up and running. So what I'm gonna do is I'm going to turn the camera off and I'm going to show y'all I'm going to attempt to show y'all the case. And y'all let me know if y'all can see the case or not before I start reading it. Okay, we're turning the camera off and here we go. We're gonna go to screen share. And the case that I want to show y'all is here. Okay, what is this? That's the live. Okay, y'all. Well, let me turn the. Sorry about that, y'all. I had to turn that off. Okay. Can y'all see can y'all see my screen right now? Let me know if y'all can see the screen right now. And I'm gonna scroll down. I'm gonna start reading y'all this case. It's about 6 pages. It's not gonna take too long. It'll probably take me about maybe 15 minutes, but I want to read this case. So I'm gonna scroll back and see. All right, cool. It's working. Good. All right. So I'm gonna go ahead and I'm gonna start reading the case to y'all. This is in a chancery court, which is another word for an equity court. So what we got? Petition by W.H. Sweeney and others to have a judgment over annulled and vacated for want of jurisdiction of the person. So he's trying to get this judgment vacated for lack of in personam jurisdiction. From an order denying the petition, petitioner appeals. So he appeals the order, the court reversed the judgment and remanded it back down to the lower court. And they're going to explain it to you why. Y'all forgive me if I can't pronounce some of these words. I'm sorry. Leo Trisich, an assignee, filed his bill against W.H. Sweeney and others to enforce a vendor's lien upon a sale of the property and the failure of the same to bring a sufficient amount to satisfy the decree. A judgment over was rendered against the non-resident after publication. So when they say after publication, they're talking about service by publication. Service by publication is it's basically you are attempting to serve the defendant because you can't find them, so you're attempting to serve them in the public newspaper in a particular county or city where they live, even if they don't see it. As long as you did it for, like, some states might require you to do it for like 4 weeks or something like that. Once you do that, then they'll go ahead and issue a judgment for you. And particularly this would probably be a default judgment. No personal service was had, so they never perfected service of process against him. So let's see. And I think this is their argument right here. So the appellant, it says wait a minute, hold on. Well, this is the appellant. Okay, a court which okay, so this is what they're doing. This is the appellant's argument right here. This is what he's arguing right here. And I think on down you will see the appealee, and you're going to see their argument, and then you're going to see what the court held. Okay, a court which has made a final order or decree, which on the face of the record or proceedings is void, should vacate it whenever its attention is called thereto by appropriate application for that purpose. So they're telling you that that's what you have to do if the judgment is void. After the expiration of the term at which a judgment is rendered, the proceedings in the cause are final and the jurisdiction of the court is exhausted, except for amendment or the correction of clerical misprision, the record furnishing the evidence therefore. Where are we at? Okay. The appearance for the purpose of making the application, meaning the motion to vacate the judgment. He made an application in the manner of a motion to vacate the judgment. So he made that application on a special and not general appearance as to give the court jurisdiction of his person. So he made a special appearance, not a general appearance. Appeal will lie from order refusing to vacate a void decree or judgment. So they're telling you that you can appeal it. And whenever they're refusing to vacate a void judgment or decree, you can appeal it. That's what they're saying. And these are all Alabama cases, just to let y'all know. But this is where y'all need to go to read and to understand what's going on. You need to go and read these old cases. And although I'm reading an Alabama case, this does not just apply in Alabama because this is a principle. Service of process is due process. They have to give you due process. Anytime they violate well, I ain't gonna say anytime, but it seems like generally speaking, it depends on what type of process is due. But I know like service of process, you can vacate a judgment when they fail to perfect service of process on you. You can vacate that judgment. Okay, the appealee. Now this is what the appealee is arguing. Under its allegations, the petition was wholly insufficient and defendant is barred by lashes. That is an equitable remedy. That is an equitable affirmative defense. And by the statute of limitations. So that's what the appealees is arguing, not the appellants. Under Section 859, Code 1896, an execution issued for the balance found due after sale. The decree over is within the, I'm not sure what that is, the lis pendens, and further notice is not necessary. So we're going to go down. If I'm not mistaken, this is what the so-called judge is holding. This is what they're going to say. This is the ruling right here. Upon bill filed to declare and enforce against a non-resident, as shown on the face of the bill, a vendor's lien, a decree was rendered granting the relief prayed. So they granted what he was wanting. They granted him the relief he was asking for, his remedy. And after sale of the property subject to the lien, a balance of the indebtedness found due remain unsatisfied. Thereupon, without other notice at any time than by publication. So they served him by publication, like I just mentioned earlier. A personal decree over for such balance was rendered. After the lapse of 10 years, after the lapse of 10 years, the defendant, still not a resident, petitioned the court in which the decree over had been rendered to vacate it on the grounds that such decree was void, since he was not brought into court by personal service. Pay attention, y'all. The petition was dismissed conditionally. It has been settled since the leading decision, and y'all might want to go in. I'm going to highlight this for y'all. Y'all might want to go and read that case right there. It has been settled since the leading decision, I'm not really sure how to pronounce it anyway, was pronounced that a personal judgment or decree rendered in a cause against a non-resident upon whom no personal service therein was had is void. Of course, and of course, unenforceable in any manner. That doctrine has been several times affirmed by this court. While a court is without power to alter, vary, or annul final judgments or decrees after the close of the term at which rendered, except for the correction of clerical misprision or amendments, the evidence of which the record affords, yet where it appears on the face of the record that the judgment or decree is void, either for want of jurisdiction of the subject matter or of the party. When they say of the party, they're talking about personal jurisdiction. They're talking about in personam jurisdiction. It is the duty of the court, upon application thereto by the party having rights and interests immediately involved, to vacate such judgment or decree at any time, to vacate such judgment or decree at any time, to vacate such judgment or decree at any time subsequent to rendition. And this, out of a due regard to its own dignity, the protection of its officers. I wonder why they say the protection of its officers. Probably because they were not be entitled to any form of immunity. That's what I'm getting. And the prevention of abuse of its process and of injustice to its suitors. Slow down some more. I'm almost finished, y'all. We got about 2 or 3 more pages. Let's see. And it appears that this court has repeatedly, that this court has repeatedly, in the cases referred to, recognized the right and the propriety of appeal, whether the order to vacate be granted or refused. The decree here in question being, as shown by the face of the record in the original cause, utterly void, the application of Sweeney should have been granted. This man waited 10 years to petition to vacate a void judgment, and they still granted it. 10 years. Sorry if I'm so loud, y'all. I'm sorry. Should have been granted unless as insisted by appealee. So pay attention, because this is what the appealee is arguing. Pay attention. The appealee is going to start arguing what people have been saying, and I'm telling y'all that you're wrong. As insisted by the appealee, the lapse of the time has affected his rights in the premises, or unless his appearance by filing the motion under consideration gave the court jurisdiction of him as a party defendant in the original cause, and justified the reopening of that cause and the rendition of a judgment against him. Pay attention. In our opinion, neither of these contentions can be sustained. In our opinion, neither of these contentions can be sustained. So they're saying, no, we don't agree with that. We don't agree with that. Just because he filed a motion, that does not give this court jurisdiction. Just because he filed a motion to vacate a void judgment. That's what they're saying. With reference to the first proposition, this court in Pettis versus, not sure how to pronounce that anyway, and also in Baker versus Barcliff, declares unequivocally that the lapse of time can have no effect to qualify the right to have a void decree, void as shown by the face of the record, vacated. So you can vacate that void judgment whenever. This man waited 10 years, y'all. 10 years. To the same tenure is the announcement of the court in Chamblee versus Cole, Alabama 128, 650. Let's see, right here. And stating the principle in its breadth, discussing the void decree. Freeman on Judgments in section 117 says, for if it be null, no action upon the part of the plaintiff, no inaction upon, let me rephrase that. I'm going to read this to y'all. I got to highlight this because I need y'all to see this, man. Y'all got to pay attention. For if it be null, no action upon the part of the plaintiff, no inaction upon the part of the defendant can invest it with any of the elements of the power or validity. In accord with the foregoing is 23 encyclopedias. So they must be citing a legal encyclopedia. And cases cited in note 16, the appearance in this proceeding was in no sense an appearance. So he filed the motion. They said that's still not an appearance because he filed the motion. Y'all see that right there? Let me highlight that for y'all again. I need y'all to see that. The appearance in this proceeding was in no sense an appearance. General or special. So they saying he didn't make a general appearance or a special appearance in the original cause in which the void personal decree was entered. That cause had in an orderly manner progress to a valid decree declaring the lien and effecting the sale. Without the jurisdiction possessed in the cause, there being none over the party defendant, therein warranting a personal decree over or against him, that cause had run its course, and the court had fully and wholly exhausted its powers, except only for amendment or correction of clerical mispresence, the record affording the evidence thereof. Let's go down. But if the rule stated were not so conclusive, it would smack of gross injustice, as well as make the court a party to the misapplication of its powers and processes, to fasten its jurisdiction upon one not lawfully within it when he comes to relieve himself of the void decree of the court, and at the same time to conserve the interests of all parties and the dignity of the court. Such a practice, if permissible, would invite the assumption of jurisdiction of a person not subject to it, but who was brought within its reach by the illegal and void act of the tribunal seeking its judicial power over him. Let's go down some more. The result would be that in every case where there was an unservable defendant, a judgment could be rendered and thereby compel him to let the void judgment stand unquestioned and unremoved, unless he were willing to submit to the jurisdiction of the court. The law is otherwise, regardless of the merits of the matter in which the decree or judgment was or was desired to be rendered. It follows that the motion to vacate the judgment should have been unconditionally sustained and its prayer granted, and that the proper orders may be entered below. The decree appealed from being reversed, the proceeding will be remanded to that end, and that'll be it for that. But I had to let y'all know that. I had to let y'all know that a void judgment is a void judgment. That's just all it is. A void judgment is a void judgment. I'm going to stop screen sharing. I'm going to go back to the chat. Let me turn this off. And we'll get right back to it. Okay. All right, y'all. All right. So how was that case? Did that case help y'all any? Looks like it just, what does it keep repeating the same thing over and over? Let me see what happened. So there must have been some type of lag in it. Okay, there we go. Okay, y'all. Sorry about that. I had to read that case for y'all. So does anybody have any comments in regards to what I just read? Did you not understand it? Did I confuse you? Would you like me to read a certain section of the case again? Talk to me. There's a call-in number too, y'all. Let me check the phone lines. I'm sorry. I'm gonna post the call-in number into the chat. Where's that call-in number? Let me get this call-in number for y'all. Give me a second. Okay, let's get this call-in number. All right, y'all. I just posted the call-in number into the chat. So if you want to call in, call in. If you haven't hit that like button, go ahead and hit that like button. That was a short, sweet case, straight to the point. Straight to the point. Okay, Stillness Jackson, 9.5. Now, if y'all have any questions, let me know. I'm finished reading the case for right now. If y'all have any questions about anything, let me know. If I can answer the question, I'll answer the question. When you call into the show, you have to press one. Press one if you want to talk, and I'll turn your microphone on. Where is? I'm doing some research right now, y'all. So I'm sorry. If you want that case citation, let me know. The case that I just read, if you want it to go and read it for yourself, let me know, and I'll see if I can post it into the chat section for you. Okay. All right. Now I found some stuff about what is it called? How to it's just basically explaining to you how to recuse a judge. I haven't read it yet, but it looks very interesting. So that's some stuff I'm gonna be studying. So anybody have any criminal cases, state, federal? I might be able to answer some of those questions. Civil cases, state, federal. Depending on what it is, I might be able to answer it. It was a what is that? It is our duty to declare the law is written, not to make it. I have to read that. This is why I keep telling y'all have to go and read. Y'all need to go and read these old cases, man. Y'all need to go and read these old. I'm gonna see if I can find this. I think that thing is like 68 pages, though. I might not have time to find it and doing this live. I don't want to bore y'all. Uh, where is it? I'm gonna pull up some files. Right, I'll be right back, y'all. I'm gonna be in and out. Y'all, if you have any questions, you want to call in, press one. If you just want to listen, that's fine. I'm about to do some research. See if this file is gonna pop up. Where's that disk at? All right. This one, just disqualification. I'm sorry, y'all. Scope, disqualification, accuser. These are words that send a slight chill up to the spines of all good attorneys. But how? Um, Introduction. This stuff look real good. This is all of this stuff that I'm reading right now that I'm looking at. This is in Texas. So if you're in Texas right now, you're probably gonna want this. This is some good information. Types of removal. Judges may be removed from a particular case because they are one constitutionally disqualified. Didn't know that. Recused under the rules promulgated by the Supreme Court. Okay, I knew that. The requirements and procedure. Let me see. Hold on. Or three, subject to a statutory strike. Didn't know that. So this is in Texas. The requirements and procedures for each type removal are fundamentally different. But this is all in Texas though. But this is some good information. And I'm sure they're citing corporate juris civilis, so they're citing some principles and some case laws and some Black's law dictionaries and stuff like that. It's just some pretty good stuff. Let me go back to the live stream. Northwest Ordinance clear to the Articles of Confederation. Have you ever got? I've heard of it. I have heard of it, but I never I haven't studied it yet, but I have heard of it. What it do, Jr. Was good, man. Was good. Was good. Um, if y'all just tuning in and y'all missed me reading that case, I'll upload the video tomorrow. But that is a good case. That case basically explains to you. I'll go ahead and restate it. That case basically explains to you just because you file a motion in court doesn't mean that you are granting the court jurisdiction. That's exactly what it means. Matter of fact, who was that? Somebody is having this issue right now, in a court in Missouri, and I think it's Romeo. I think it's Romeo. All right. Let me check the phone lines. All right, caller 4249. You're on the line. How you doing? What's good, man? What's good? Let me turn the volume up. I can't really hear you. Hold on. It must be as loud as it go. Yeah, it's probably loud as it go. Well, go ahead, man. We'll make it do what we can do. I'm gonna have to get something to fix that. Oh, okay. What's up, man? What's up? Okay. 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 You say when does discovery end? Yeah, that is weird. I got a case here. I'm gonna skim through it and see. 'Cause this is a little new to me too. So the Rule 402 conference and guilty plea. The trial court conducted a 402 conference, blah blah blah, with the parties. Defendant was not present, although the record does not include transcripts from the conference. At a later hearing on defendant's motion to withdraw his guilty plea, defense counsel testified about what occurred at the conference. Trial court conducted. I got to go down to the law because this is some sort of colloquy, and they're reciting what happened in the case. But I need to go down and see what the how they have interpreted this. The trial court informed defendant that one, he did not have to plead guilty. No, that's not it. Where is it at? This is that's a little weird right there. That's very weird. All right, I'm gonna let me read you something, and if you hear anything that stands out, you just stop me. Because I really don't know in regards to this particular issue. I really don't know too much about it. That's a little confusing too, because I don't really study that. But anyway, Rule 402 provides in relevant part that before a guilty plea may be accepted, the trial court must personally admonish the defendant in open court about one, the nature of the charge, two, about the minimum and maximum sentence, three, that the defendant has the right to plead not guilty, and four, that no trial of any kind will occur if the defendant pleads guilty. The court must find that the plea is voluntary and that the defendant understands these admonitions. The court must confirm the terms of the plea agreement and determine whether any force or threats or promises, apart from a plea agreement, which is a contract, by the way, were used to obtain the plea. Finally, the court must determine whether a factual basis supports the. This is the same thing they do in Alabama. All of that, almost they do almost all of that in Alabama. All of it. Before accepting a guilty plea, the trial court must substantially comply with Rule 402. An imperfect admonishment is not reversible error unless real justice has been denied or the defendant has been prejudiced by the inadequate admonishment. So it seems like you try. Are you inquiring about him appealing to try to get it reversed to find some sort of let me see some sort of imperfect admonishment? Is it something like that? Hold on, she didn't what? She didn't what at all? If you got a record of that, I don't see how you can't get that vacant. I don't see how you can't get that overturned. Uh huh. Man, I'm looking around. I'm looking around in my place. I thought that thought that was over here. Uh huh. Okay. He ought to be able to get that vacated, man. He should be. I'm sorry to cut you off. He should be able to get that. He should be able to appeal that and get that overturned, depending on the statutes of limitations, something like that. But this seems like some sort of due process requirement, and if they violate due process, then any subsequent order issued in regards to that particular hearing is void because they violated due process. You can't do that. If you say she didn't give you if you saying that she didn't give him any admonishment, I would reasonably conclude that not the fact that she didn't give him any admonishment would be the same thing as an inadequate admonishment. You see what I'm saying? I would say that he has been prejudiced by the inadequate. She didn't if you're saying she didn't give him anything, she violated due process. Mm, if you're saying that this is criminal, then she had to do that, man. She had to admonish him. I'm gonna I think I'm gonna have to. I'm gonna see if I can. Matter of fact, I'm gonna copy the case citation what I'm reading. But let me see. I'm gonna read over. Let me check the chat right quick to see if I have any more questions. Let's see one verse. Okay, I'm gonna be back and forth to the chat section, y'all. So just give me a minute. I'll get your questions answered as soon as I can. Uh, okay. Let me go back to this case. The Rule 6 of the certificate, defendant believes that the record rebuts the legitimacy of his post-plea consensual certification. Since the defendant contends that counsel intentionally omitted from his original statement that he will renew the sentence. The law governs the procedure to follow when the defendant wishes to appeal from a judgment. Okay, I'm gonna read this, and you tell me if this applies. Rule 604D governs the procedure to be followed when a defendant wishes to appeal from a judgment entered upon a guilty plea. The rule requires that that defendant's counsel to file a certificate with the trial court asserting as follows. One, I have consulted with the defendant in person, by mail, by phone, or electronic means to ascertain the defendant's contentions of an error in the entry of a plea of guilty and in the sentence. Two, I have examined the trial court file and report of proceedings of the plea of guilty and the report of proceedings in the sentencing hearing, and I have made any amendments to the motion for necessary adequate presentation of any defects in those proceedings. Blah blah blah. He's saying, well, in this particular case, he's saying that his attorney did not comply with this rule or something like that. Rules strictly comply with the requirements. If a certificate is determined to be deficient, then the appellate court is required to remand the case to the trial court for proceedings that strictly comply with Rule 604D. We reviewed de novo issues of compliance with Rule 604D. You probably gonna want to read this case. When did he get a well, you know what? I was going to ask you when did he get a judgment against him, but it really doesn't matter because a void judgment is a void judgment. All right, give me 1 second. I'll be right back. Give me 1 second. Sorry about that, man. Uh-huh. Uh-huh. That's something I'm gonna have to study. They doing some weird stuff out there in Illinois. That I can't even give you. I can't. Go ahead. I'm sorry. Uh-huh. Yeah, it sounds like it. I right now that's something I would need to study. I don't want to give you the wrong advice, but I can tell you based on what you're saying me in regards to the admonishment that she violated due process. Sounds like to me. And if she issued any and if she issued any order subsequent to that hearing where she violated due process, that is a patently void order on its face. It is void. It's void. It has no standing. I just read a case that just said that. I just read a case that just said that. Yeah, she violated due process. Yeah, but he's gonna have to either he gonna have to hire himself an attorney, or he's gonna have to take matters into his own hands. That's unfortunately that's just it. That's just how it works. That's just it. It ain't really no way around it. And when when you're doing this by yourself, they don't really play fair. Let me see. Hold on, because I got somebody else on the line too. So give me. I'm gonna wrap this call up in about 30 seconds, and then I'm gonna go to the next caller. So again, that's something that I would have to study. But I can say, yeah, he can motion to vacate that judgment because it's void because she issued it in a manner that's inconsistent with due process. She struck it. That don't mean he just because she struck his motion. That don't mean she wrong. I mean, that don't mean he wrong. I would he should be able to either do some sort of mandamus or some sort of interlocutory appeal, something like that. And in the process of doing that appeal, file a motion to stay the proceedings in the trial court. Or if it gets denied there, and if they let you do it in the appellate court, file a motion to stay the proceedings up there and see if it's granted. No problem, man. No problem. All right. All right. All right. Peace. All right, caller 0123. You're on the line. How you doing? 0123. That's all right. What's good? How you doing? Can you hear me? Okay, go ahead. How you doing, man? Um, did they issue due process against you? Did they perfect service of process against you? Meaning did they serve you a summons and a complaint? Well, it, okay. If they never served you, then it's void, man. I just read a case that just said that this man vacated a judgment after 10 years. 10 years. 10 years he got because they never perfected service of process against him. Also, there's an ebook. I'm not sure if you got that ebook, but it says the title of the ebook is the child support remedy. And I got some videos on my YouTube channel reading that ebook. You need to go and either watch those videos, or you need to, when you get time, send me your email address and I'll send you a free copy of that book. It's not mine. I'm just giving it away. They told me I can give it away, so I'm just giving it away. But your remedy when you read that book, your remedy is in equity, because they have deprived you of a property interest in your child, in your seed. And because they deprived you of that, um they owe you some type of equitable relief if you are not the cause of that right being stripped away from you, so to speak. They owe you a remedy. Well, all of this stuff is administrative, man. They are all following statutes. That's like that's exactly what they're doing. But they have to give you I want to say it's pursuant to the 14th Amendment, I think, that mandates that they have to give you due process. So that means procedural and substantive due process, if I'm not mistaken. So they have to give you due process. So your administrative procedure is in some sort of statute. Your remedy is listed in some sort of statute. Sometimes the remedies are not listed in a statute, like what I just told you about the child support remedy. That's not listed it's probably not listed in a statute where you are. They hid that, man. They hid that real good. If he never sent it to you, then you never. It's void, man. All you look, man. Anytime this is what's going on, man. When they mail stuff out to your house, there is a presumption that you got the mail. Let me rephrase that. There is a rebuttable presumption that you got the mail and you just said, you know what, forget them. I ain't going to court. So how you rebut that presumption is you either file an affidavit or you file a motion to vacate the void judgment for lack of in personam jurisdiction for lack of due process. Because you coming in and you saying that, look, I didn't y'all saying y'all served me, I didn't get anything. I didn't get nothing. Y'all saying y'all it's a presumption, man. The entire record, all of that stuff is all of it's just presumptions, man. It's all that's all it is. Anytime you see something like let's say you get a court order and you see something in the order that's untrue, then you file an appeal to it or you object to it. So if you don't object to it, they're going to assume that it's true. That's why you make your objections right there in open court, because if you don't in the trial court, they're going to say you waived those objections because you didn't make them in the trial court. Anytime they say anything, anytime anybody in court say something and they not a witness, you object. Anytime somebody in court trying to get evidence admitted pursuant to some document or something like that, and they don't have firsthand personal knowledge and they're not competent to testify as to the veracity of the contents of those documents, you object. I don't care what it is, a video, a cell phone, a text message, a witness, you object. I don't know too much about that. I would have to go and read that statute, and well, I would need to go and read some cases on that statute. I don't really know too much. I don't even know what that statute is, to be honest with you. Okay. Well, again, like I stated, I don't really know too much about it. I can tell you that they're receiving federal funding. So if they're receiving federal funding, uh, they um they have to comply with due process. Is this the carpenter we want to to a certain degree, that might be, to a certain degree, that's true. But generally speaking, federal law, in some cases, takes precedence over state law. If I'm not mistaken, if state law is in conflict or is contrary to federal law, I think that's a better way to say it. When you get time, man, put your email address in the chat section, and I'll send you a copy of that book. On a scale of 1 to 10, how well can you comprehend legalese? Yeah, well, that's good then. So if you that good, that's good. You should be able to litigate the case. You should be able to file your motions and stuff like that. You need to go and read your what state are you calling it? You don't have to tell me if you don't want to. I will go and read the North Carolina Rules of Civil Procedure. I'm not sure if that's what they call them. But that's what you need to go and read, or the North Carolina Rules of Juvenile Procedure, or something like that, because all of this stuff that I'm telling you is in those rules. in regards to due process and what happens when you don't get due process. You can file a motion to vacate the judgment. You can file appeals. All the, generally speaking, most of that stuff is it's inside the rules of procedure. Yeah. Okay. Okay. Well, I appreciate you calling in, man. Good luck. Good luck to you. All right. So let's get back to the stream. Okay, y'all. Somebody said they can't hear the caller. Can y'all hear me? Is anybody having issues with hearing anything right now? Let me go to the chat and see what's going on. I'm sorry, I done missed so many messages. Um, to squash a bench warrant for not paying traffic fines, they will not allow me to so-called sit it out. I have been so-called kidnapped at traffic stops, only to be held for a few hours, then let go. Hmm. Stillness. What's the purpose of them arresting you at this traffic stop and then letting you go? Why are they letting you go? That don't make sense to me. Sweeney versus Trisha. The case involves a bill filed to declare and enforce a vendor's lien against a non-resident. The case also shows that jurisdiction is affirmatively shown. I will read it. Castle Rock versus Birmingham is a Supreme Court case that stands for the proposition that police are not required to enforce the law. I asked a sheriff 3 weeks ago. Policy is not law. No, policy is not law. To me, the term policy is corporate in nature. I did a video on because they say public policy is the law. That's what they say. First, public. Public ain't got nothing to do with me or you. And then they say policy, public policy. So you know what? I was like, well, what's public policy? What is it? What's the scope? What is it? Where is it applicable and where is it not applicable? What is public policy? And if y'all go and watch my video called WTF is public policy, which is basically what the fuck is public policy, they don't even know what it is. Nobody knows what it is. Let me rephrase that. It's not substantiated on the public record, so we can read it as to what it is and as to where it's applicable and where it's not applicable. I'll say that because I don't know. I don't know what it is. Uh, Here they want to elect a sheriff by a group of city people, not by a vote of the people, not the county. I don't see how that would be unlawful if they wanted to do that. Oh, so y'all saying y'all couldn't hear the caller? Is that it? Y'all couldn't hear anything the caller was saying? If y'all couldn't, I'm sorry about that because I don't know why. I heard everything he was saying though, but I'm sorry. Probably the volume is too low. 11 years in prison till it got to the Supreme Court and let him out. Police and prosecutor lied. Boy, 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 ain't nothing. Ain't I'm not surprised by that at all. Peace, bro. Funds are shaky, but I definitely need your services. The transcript came in Friday. What claims can be asserted if falsely arrested because a name mix up? Dealing with a legally changed name. I mean, they unlawfully arrested you. What claims can be asserted if falsely arrested? Assault, battery, probably intentional infliction of emotional distress, deprivation of your right to liberty, without due process of law. That's a substantive right. What else? I don't know what false imprisonment, probably malicious prosecution, all that stuff. I'm just going off the top of my head here. Uh, Man, I am almost to the point to where I'm almost at the first stage of monetization to where I can monetize my channel. Y'all can call in if y'all want. I'm gonna put the call in number back into the chat. There's the call in number if anybody wants to call in. I'll be here for probably about 45 more minutes, and then I'm gonna get on up out of here. Let's see. This video, with this live right here, I'm not gonna upload it tonight. It'll be tomorrow morning. It'll be added. If you just tuning in and you haven't hit that like button, please hit that like button for me. Don't be stingy now. Stop being stingy. Um, that Sweeney versus Trish's case that I just read, that was from 1907. 1907. That is a good case. That is a good case. Oh boy. So let's see where we at. Where we at? Let me plug this. Let me plug my laptop in, y'all. It's going dead. Give me a second. Okay, sorry about that, y'all. Had to get that done. I can hear you, just not the caller. Motion. Section 3013.5 agreements to use the federal parent locator services in parental kidnapping and child custody or violation cases. Um. Okay, what exactly do you want to know about that, Ocean? Uh, let me go and check the phone lines. Hit that like button for me, y'all. A friend in federal court asked his lawyer, who is the victim. The lawyer said, off record, told him the prosecutor is the victim. How is that possible when there is no affidavit from a victim? He's lying. The prosecutor is not the victim. The corporation called the United States is the victim. But you can't subpoena the United States to come in and testify. The prosecutor is just a prosecutor for the United States. I mean, that's really, in other words, he's enforcing that corporation's rights because corporations have to enforce their own rights. That's essentially what it is. Oh boy. All right. Let's see. All right. Well, I guess I'm gonna start reading stuff. Pick up and we'll start reading. So let's see. What there was a case. I don't know. I kind of want to get into. I'm gonna have to find those cases, y'all, because I'm on a new laptop and I don't have the cases on this computer. They're on another computer. Um, so we'll get into 303 scope and applicability of this part. This part prescribes the minimum organizational and staff requirements the state Title 4D agency must meet in carrying out the Title III program. Okay. You need to if you haven't, Ocean, I would suggest because I don't really too much study that, but the book that I have, the child support remedy book, I think they do mention some of that in that book. And if you haven't gotten it already, just put your email address below, and I'll get you a copy of it. I'll email you a copy of it. I'm asking, since it is the minimum requirements of the state Title V agency to provide that service, why didn't they? Um, I'm not sure why they didn't, but if they didn't and they were required to, then they probably violated due process. I'm assuming they violated your due process right since you're asking about it. I'm assuming. I'm not really sure. But they have to give you due, if they're taking federal funding, if they're taking federal funds, they have to give you due process. Ain't no way around it. They have to give you due process because anytime you're doing business with the government, they're going to require via some sort of contract that you adhere to due process. You don't do anything any of the such of what they call the invidious discrimination against anybody. That's what they're going to require as a condition of the contract that they are entering in with you. I know because my business, I've been trying to get contracts in my business. I mean, with my business with the federal government, and this is what they require in their contracts. Let's see. I found something very interesting. I'm gonna see if I can find it. Is that it? I've been wanting to read something about this for a minute. Oh, I spelled it wrong. Okay, there we go. Okay, necessity has traditionally been a justification for conduct that would otherwise be criminal. When the necessity applies, it justifies the defendant's conduct in violating the literal language of the criminal law, and so the defendant is not guilty of the crime in question. Now that is interesting. How many of y'all have ever heard of the defense of necessity? So it's an affirmative defense, the defense of necessity. How many of y'all have ever heard of that? What I'm gonna do is I'm gonna do my I'm gonna screen share again because I just found this stuff, and this is something that I found that was very interesting. I'm guessing the defense of necessity is similar to self-defense or something like that. Let me check the phone lines. I'll be checking the phone lines back and forth. Let's go. Where we at? Right here. All right, I'm about to turn the camera off, y'all, and we're gonna focus on the screen for right now. All right, and we are here. All right, so I want to focus on this, y'all. This is very interesting. Um, Now I'm just studying this like on the air, like I don't. This is just random, but this is very interesting to me. This is a Ninth Circuit case concluding that the defendant is not entitled to present the defense of necessity because the evidence, even if believed, could not establish that the defendant reasonably anticipated that his criminal conduct would avert the harm he sought to avoid. Noting that the defense of necessity has been recognized in prosecutions for a non-violent prison escape, kidnapping, and false imprisonment. Now that's interesting. Um, Let's see. I'm gonna read this right here. This is a California citation, so I'm gonna read this. Common law historically distinguished between the defense of duress and necessity. So there's a distinction between them. Duress was said to excuse criminal conduct where the actor was under an unlawful threat of imminent death or serious bodily injury, which threat caused the actor to engage in conduct violating the literal terms of the criminal law, while the defense of duress covered the situation where the coercion had its source in the actions of other human beings. The defense of necessity or choice of evils traditionally covered the situation where physical forces beyond the actor's control rendered illegal conduct the lesser of two evils. That's funny. Let's go down and read that. Thus, where A destroyed a dike because B threatened to kill him if he did not, A would argue that he acted under duress, whereas if B destroyed the dike in order to protect more valuable property from flooding, a claim uh, uh, A could claim a defense of necessity. This is interesting. An underlying premise common to both defenses is if there was a reasonable legal alternative to violating the law, a chance of both to refuse to do the criminal act and to also avoid the threatened harm, the defense will fail. Now that's interesting. Very interesting. Let me get back here. I'm gonna be monitoring the chat from time to time too, y'all. What I don't understand and read into warrants is how come lawyers want plea deals when it's a bad warrant? Mind-boggling. I was told by a clerk everything they have gets sent to the treasury bonds. It wouldn't surprise me. The reason, in my opinion, man, is because they all working together, man. Ain't no like that's it. They all working together. That's the whole purpose. That's it. They working together. They all in cahoots. They all acting in concert. That's the reason, in my opinion. Affirming the trial court's ruling preventing defendant from presenting evidence of the affirmative defense of necessity. This is how I do my research, y'all. This is how I do my research. We first address the requirements of an instruction on the defense of necessity. Necessity is a defense wherein conduct otherwise unlawful is justified if the person reasonably believes the conduct is eminently necessary to avoid imminent harm. And two, the desirability. Disconnected, reconnecting. Let's go back. If there's anything wrong with the live, y'all let me know because I'm getting something that's saying it's disconnected. Okay, so we'll get back to it. All right. If you haven't hit that like button already, y'all hit that like button for me. Let me go back to the comments and see what I got. If I missed anything, let me know. The transcript came. Oh, yeah, I already read that. I already read that. Israel, just get at me when you get time, man. Yeah, get at me when you get time, fam. I'm sorry. It's all good, man. We all go through it. Just get at me when you get time. But if anything changes on my end, I'll let you know. Let's see. Where I'm looking this thing. I got about 30 minutes left on the call, the air. So y'all let me know if you have anything I want to talk about. If you're new to this channel, thank you. Thank you for hitting that subscription button. Really appreciate it. Thank you for turning that notification bell on. I really appreciate it. Um, excuse me. Any questions, just let me know, y'all. Just let me know. Excuse me. I'm not sure. What is that? I don't know. What is that? It's episode 7. This must I must got I probably got to delete that. I got to delete one of them because I don't know what that is. Episode 7. That was yesterday. All right. Well, I guess what I'll do is I'm gonna pull up something that I want y'all to see. Um, you're probably gonna want this when you see it. Let me get my flash drive. Here it is right here. Let me get my flash drive. Get some good information on this flash drive. I did this in a video once, but nobody. There's a problem with this. Uh, let's see. I showed this in one video once. Some people jumped on it, some people didn't jump on it. I guess they didn't want it. Some people didn't. But when I show it to you, you're gonna want it. Scanning repair. So I think it's called Fourth Amendment jurisprudence or something like that. This was done by an attorney in I want to say California. I believe it's California. So let me pull this up for y'all. And what you need to do when I pull this up, if you want a copy of it, just drop your email address down and I'll email it. Um, you need to read, man. Y'all need to read. I'm gonna keep saying I say that so many times. You got to read, man. You have to read. Read, 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 read. Eventually you gonna like you won't even have to read it anymore because you're gonna already know it. It's gonna make so much sense to you. Let's close this. It's loading up right now, y'all. Give me a second. I'm sorry. It's loading up right now. Taking a little minute, but it's loading up. But this is gonna be some great information. So I almost finished loading. Come on, come on, come on. I have a lot of information on this flash drive, so that's the issue. A lot of information on it. Uh, it's like right here at the finish line, y'all. It just won't even load. Come on now. There we go. Okay. So here we go. Okay. Fourth. FOU. Fourth Amendment. I think it's this right here. Bingo. Here we go. Right here. All right. Where we at? All right, y'all. This is it right here. I'm gonna make this a little bigger. for y'all to see. This is great information. I strongly advise y'all, okay? I strongly advise y'all uh to, when you get time, either email me or drop your emails below. Preferably just send me an email to my email address, which is smartloketv@gmail.com. And I'll respond as soon as I can. The reason why I say that is because YouTube tends to block email addresses when you post them below, because I think they see it as spam or something like that. I'm not really sure. But anyway, this is 788 pages. Nothing but case law. Nothing but case law. So I'm gonna show you. Scope: due process, initially intended to control the actions of the federal government only. And there's right there, boom, 1833. The United States Supreme Court eventually ruled that a violation of the Fourth Amendment by state, which includes all county and municipal authorities, does not in fact constitute a Fourth Amendment due process violation, thus imposing compliance. I'm sorry, not does not, but does in fact constitute a Fourth Amendment due process violation, thus imposing compliance with the protections upon the states as well. So that's the 14th Amendment. Y'all should already know that. But I'm just gonna go in and I'm just gonna explain some of this stuff to y'all. And I'm showing y'all that this man, he put in a lot of work when he did this. A lot of work. This thing is 788 pages. The 14th Amendment provides that no state shall deprive its citizens of life, life, liberty, or property without due process of law. Violations of the Fourth Amendment constitutes such a deprivation. Also, the Fourth Amendment protects against trespassory searches only with regard to those items, i.e., persons, houses, papers, and effects. Effects are essentially personal property. It's another word for effects, just to let y'all know. Now, when they say papers, I'm not really sure what they mean by papers, other than probably maybe like a newspaper article or something like that, where they well, you know what? I don't know. I can't even comment on it. I'm gonna have to go and read that. I don't even know. That it enumerates the exclusionary rule. The Fourth Amendment serves as a primary basis for the exclusionary rule. Remember when I said wherever there's a right, there's a remedy. So whenever they violate your Fourth Amendment, in other words, whenever they unlawfully arrest you, then any evidence subsequent to that unlawful arrest, or in other words, any evidence incidental, any evidence relating, any evidence stemming from that unlawful arrest, is inadmissible as a matter of law. Excluding evidence from the courtroom which would be otherwise admissible when seized by law enforcement in the violations of its terms. History: the exclusionary rule was originally adopted in Weeks versus United States. This is 1914, which barred evidence obtained by federal officers in violation of the Fourth Amendment. The Supreme Court subsequently held that the rule was not constitutionally imposed upon the states. So I'm guessing they must have changed it, because this was that 1949. It was not until 1961, when Wolf was overruled, that the exclusionary rule was made mandatory in state prosecutions. The primary purpose of the exclusionary rule is to deter future unlawful police conduct and thereby effectuate the guarantee of the Fourth Amendment against unreasonable searches and seizures. I am so glad they did that, because if they wouldn't have done that, then I don't see any other way to get that evidence struck from the record, to get the evidence that was unlawfully seized not admitted into evidence to be considered by the jury. Let me go back in and check. Let's see. Trigger bonds. Hi. Why do probate allow closed estates to be reopened to give your estate will to an attorney so that they can sue over the buyer? That's a good question. Um, Why do probate allow closed estates to be reopened? There has to be some sort of maybe jurisdiction where some it's probably some sort of due process, some sort of um equitable principle or something like that. It says, have you ever tried the AEL programs to look up case law? No, I've heard of them. No, I think AI is pretty good, and I do think that they make people's lives easier, but they also make you lazy. That's my contention. That's what I believe. That's why I don't really want to use AI, and if I do, I'm not going to use too much of it. Let's see. You give great work. I have PDFs I would like to share with you. You can go ahead and share them, man. Just send them to my email address. Send them to my email address. Is that rule under the Fifth Amendment for remedy? What rule? You mean the exclusionary rule? Katz was another case, in my humble opinion. I cannot remember the case on wiretapping. I do remember some case. You know what? It might be in here. I'm gonna go back and read it. But what I'm doing right now is I'm trying to make people intrigued into this document right here that I'm looking at, and I'm trying to make them send me their email addresses so I can send them this document so they can read over this document. The prime purpose of the exclusionary rule is not the sole one, if not the sole one, is to deter future unlawful police conduct. It also has the purpose of the Fourth Amendment to safeguard the privacy and security of individuals against arbitrary invasions by government officials. Use of the exclusionary rule is a preferable sanction over outright dismissal of the case. Noting that dismissal under a court's inherent supervisory powers might be appropriate if necessary to one, implement a remedy for the violation of a recognized statutory or constitutional right, two, preserve judicial integrity by ensuring that a conviction rests upon appropriate considerations validly before a jury, and three, deter future illegal conduct, but even then, only after the defendant demonstrates sufficient prejudice. That's pretty good. It's pretty good right there. That's a Ninth Circuit. The exclusionary rule is not an individual right and applies only where it results in appreciable deterrence. See remedy for violations, the exclusionary rule under searches and seizures below. The rule of reasonableness. Remember, y'all, when I told y'all everything they do to you has to be reasonable, it has to be reasonable. It always has to be reasonable, meaning lawful, meaning constitutional. If it is not, it is unlawful. It's unlawful. Notice, y'all, I don't never use the words legal or illegal. I always say lawful or unlawful. Also, in otherwise lawful seizure can violate the Fourth Amendment if it is executed in an unreasonable manner. Remember when I read y'all them cases that those police officers were denied qualified immunity even though they had a warrant because they executed the warrant in an unreasonable manner? Remember that? While a parole is subject to search or seizure without probable cause, or even a reasonable suspicion, searching him may still be illegal if done in an unreasonable manner, such by a strip search in a public place, checking defendant's crotch area for drugs while shielded from the public, held not to be a strip search and not unreasonable. Private persons and the exclusionary rule. Evidence illegally obtained by private persons acting in a private capacity is not subject to the exclusionary rule because the Constitution does not apply to you. It does not say what you can and can't do. You can't violate the Constitution unless you're a public servant. Even a peace officer, when off duty and acting in a private capacity, may be found to have acted as a private citizen. A civil rights action pursuant to 42 Section 1983 was held to be proper against non-law enforcement employees of a private corporation that operated a federal prison under contract. What? Y'all know how they became subject to 42 Section 1983? Because of that contract. I just said that. They want you to when the government when you are trying to do business with the government, they're going to put some sort of clause in their contract that prohibits you from violating the Constitution. See how much more time we got. I will send you email. Check spam folders, please. How using protons work. Okay, thank you. I appreciate it. Miss G, I'm sorry. I would need to study that a little bit more, Miss G, because I don't have an answer right off the top of my head. I'm sorry for taking so long to answer your question, but I don't have an answer right off the top of my head to give you. If you're just tuning in and you haven't hit that like button, hit that like button. Let's get back to it. I'm gonna keep reading this. I want y'all to get this stuff, man. Limited use of the exclusionary rule. The exclusionary rule is not intended to prevent all police misconduct or as a remedy for all police errors. The use of the exclusionary rule is an exceptional remedy typically reserved for violations of constitutional rights. To trigger the exclusionary rule, police conduct must be sufficiently deliberate that exclusion can meaningfully deter it, and sufficiently culpable that such deterrence is worth the price paid by the justice system. That's funny. The exclusionary rule should only be used when necessary to deter deliberate, reckless, or gross negligent conduct, or in some circumstances, reoccurring or systematic negligence. But officers who took 26 and a half hours to obtain a search warrant for a residence while the residence was detained, i.e., the occupant was kept from re entering, failing to recognize that they were required to act with due diligence and to expedite the process, were not excused by the rule of hearing. The resulting evidence, therefore, was subject to exclusion. That is crazy. That is crazy, man. That is crazy. But I want y'all to notice something. Notice that they're saying that this man was detained because he was kept from re-entering his house. They stopped him from re-entering his house. He was arrested. He really was arrested because he wasn't free to leave. If you ask me, that's an arrest. He wasn't free to leave. Let's see, Ninth Circuit, where a case involving the illegal warrantless search of a container was remanded for a determination of whether the exclusionary rule required the suppression of the gun found in that container. Let's see, what was that? So that must have been from that case up there. Illegally collecting blood samples from defendant, mistakenly believing that he qualified under the newly enacted DNA and Forensic Identification Database and Data Bank Act. Notice this is an act that is not applicable to me or you. Anyway, even if it was a Fourth Amendment violation to do so, did not require the suppression of the results, in that the mistake was not intentional, reckless, the result of gross negligence, nor recurring or systematic negligence. So what they just said right here was, they what they did was they said, you know what, yeah, you did violate the Fourth Amendment, but you did it in a reasonable manner because you made a reasonable mistake. That's essentially what they said. That's essentially what they said. Notice that they used, that I used the term reasonable, because if they act in a reasonable manner, but they made a mistake, their actions are going to be excused. In other words, they're going to get granted qualified immunity, unless there's clearly established law of which a reasonable officer either knows or should have known that clearly prohibit she or he from doing what they just did. Got about 12 minutes on the air. Let's see. Uh, yo, just bought the ebook. Appreciate that, DM. Support. Appreciate that. Your unseen, tireless efforts are appreciated, bro. Keep it up. We support you, man. I appreciate it, bro. Appreciate it. Appreciate it. Appreciate it. Appreciate it. I have been meaning to ask if it is possible for a hard copy of your book. Friend is locked up in Alabama. All white jury was not allowed to present witnesses given 105. That is crazy. 105 years. But that sounds about right in Alabama. That sounds about right. All white jury was not allowed to present witnesses given 105 years. Okay, did he have an attorney? Did he have an attorney? Let's see. Picked up as a person of look-alike by police. Just amazing to be held for one year in jail. He did pro se. Been trying to help him get out. Trying to help him out. So if he did not have an attorney and he did not knowingly, intelligently, and voluntarily waive his right to an attorney, or if he did not, plead guilty or something like that, there's a chance that he can get his judgment vacated. He would have to file what they call a Rule 32 petition in the Alabama Rules of Criminal Procedure, which is really easy. All of this stuff is the same thing. What he has to do is he has to plead facts that show his right was violated. Once he does that, what they're supposed to do is they're supposed to issue an order scheduling an evidentiary hearing. That's what they're supposed to do. But typically, when you pro se, when you pro se, especially when you write and you pro se, they just haters. They the biggest haters on the planet, boy. They don't want to see you win. They just hate. All they do is hate. 105 years. That's crazy. 105 years. I'm gonna go back to read some of these. Search is conducted in an objectively reasonable reliance, i.e., good faith, on binding appellate precedents in effect at the time of the search, despite a later decision changing the rules or not subject to the exclusionary rule. Search is conducted in a objectively reasonable reliance. There's that word again, reasonable. They throw it around everywhere, y'all. Everywhere. Under 28 United States Code, Section 2254D1, clearly established federal law includes only the Supreme Court's decisions issued before the relevant adjudication of the merits of a prisoner's claim, regardless of whether the prisoner's conviction became final. A direct appeal was thus the relevant adjudication of the merits. Let's see. Let me go to something else. Same to Okay. This is interesting. I need to read this. I'm gonna read this. But by the same token, not all courts are in agreement that the exclusionary rule is reserved exclusively for constitutional violations. See, the reason why I read that is to show y'all that they don't know what this stuff means, man. They arguing over what they, when it's applicable and when it's not applicable. If these people were 100% right in every opinion that they issued, you wouldn't see stuff like this. There are judges. Let me tell y'all something, man. There are so-called judges who know the law very well, but will still violate the law because they don't agree with it. They will intentionally do that because they don't agree with it. And now you got to go up through an appeal. This is costing you money. You got to go through an appeal. It's just crazy, man. It's crazy. They do this on purpose. Some of them do it on purpose. A civil rights action under 42 Section 1983 encompasses violations of federal statutory law as well as constitutional rights. Thus, Section 1983 may be used to enforce rights created by both the United States Constitution and federal statutes. Rights that are created by statutes are called positive law. Those are civil rights. Civil rights. Positive law. Those are man made rights. No man can give you rights. Privileges, maybe. At least I don't think they can give you rights unless it's, well, I would say if it's in some sort of contract, then it's really not a right. It's a privilege. Because if it was a right, you wouldn't need the contract to do it anyway. So I would say that's a privilege. But conduct by an official that violates only state law will not support a claim under Section 1983. So let's see. Let me go back to the chat. I got about 6 minutes on the line. If anybody wanted to call in. File a habeas corpus. Yeah, you can probably file a habeas corpus. Make sure their bond is put to the test. You can do that too if you know what you're doing. He has allowed a cell phone. He said there the prison does not care. They don't care for real. I mean, that ain't nothing new. A woman in Oregon got out of 4 felonies, asking the judge for his oath and to file an IRS form 2211. He is a public servant, she said, and by that allowed his tax statements. Did not know this. Not really too. I don't really study taxes too much, so I can't really comment too much on that. But I can tell you that criminal charges are taxes. It's a tax. What makes it a tax is the nature of the action, in my opinion. It's admiralty. That's what makes it a tax, is the nature of the action. The jurisdiction in which they're prosecuting the case under is what makes it a tax, in my opinion. She got out of a 20-year sentence with no evidence against her. Social Security issue, taking care of her disabled 24-year-old son. Jury convicted her even, and today she is free. That's good, man. It's real good. It's real good. Let's get back to here. I want to go to let's go. I want. Well, I think I did some videos on it, but I'm gonna still do it. Illegal detention. As a seizure of one's person, the products of an illegal detention are subject to be suppressed under the exclusionary rule. Remember when I just said that when they unlawfully arrest you, or and as a result of that unlawful arrest, they get evidence. They unlawfully obtain evidence and try to use that evidence against you. Then you file a motion to suppress because they violated your Fourth Amendment. Let's see. Detaining a defendant for drinking in public when he was not in a public place is an illegal detention and requires the suppression of the controlled substances found on his person in a subsequent consensual search. Defendant's argument that his consent to search was the product of an unlawful detention was rejected, although the court noted that he had been, I'm going to say unlawfully detained. The products of that detention, including his consent to search, would have been subjected to suppression. Fruit of the poisonous tree. In determining where the line is between the direct products of an unlawful search, which will likely be suppressed, and that which is not the fruit of a poisonous tree, which will not be suppressed, the court ruled that the following factors are relevant. The temporal proximity of the Fourth Amendment search and seizure violation to the ultimate procurement of the challenged evidence. 2, the presence of intervening circumstances, and 3, the flagrancy of the official misconduct. Using the above factors, the fact that the defendant had an outstanding arrest warrant may, depending upon the circumstances, be sufficient of an intervening circumstances, of an intervening circumstance to allow for the admissibility of the evidence seized incident to the arrest, despite the fact that the original detention was unlawful. That's interesting. Per, but per the Ninth Amendment, even though I would, man, look, if that happened to me, it wouldn't be no hope for them police officers getting up out of that 42 Section 1983 suit. Uh, but but per the Ninth Circuit, even though the fruit of the poisonous tree doctrine does not allow, does not apply to the lawful search of a residence after the house was detained. Oh boy, for an unreasonable time while a search warrant was obtained. The resulting of evidence recovered from the residence when the home was searched with the warrant will be suppressed anyway, in that the officers were not acting reasonably in the taking 26 and a half hours to get the warrant, and some punishment must follow such an unreasonable delay. Fruit of the poisonous tree. All right. Now we're going to talk about the rules of evidence, the federal rules of evidence. You have federal rules of evidence and you have all your state rules of evidence. What we at? We got 90 seconds. Let's see. Let me go back to this. Let's go back. Federal rules of evidence, Rule 402. This is why I use the word relevant right here, because it's in the federal rules of evidence. That's why I use the word relevant. Let me go ahead and stop this right quick. I'm gonna end this episode right there, and I'm gonna get back to the show. But anyway, that's why I use the word relevant, because it's in the federal rules of evidence. It should be in your state rules of evidence too. So this is why I always say, if it doesn't prove your point, do not talk about it. Period. You just act like it ain't never happened. All relevant evidence is admissible except as otherwise provided by the Constitution of the United States, meaning the Fourth Amendment, something like that, an act of Congress, these rules, meaning if these rules require the evidence to be omitted, or other rules prescribed by the Supreme Court pursuant to statutory manner. Exceptions. I don't want to focus on that. I want to get to let me see if they're gonna start talking about this evidence. Foreign entities, no. Impeachment evidence. We probably can talk about that. Impeachment evidence. Also, evidence illegally seized may be introduced for the purpose of impeaching the defendant's testimony, given in the both direct examination and cross-examination, so long as the cross-examination questions are otherwise proper. California authority prior to the passage of Proposition 8, Truth and Evidence Initiative, to the effect that evidence suppressed pursuant to a motion brought under the authority, blah, 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 was abrogated by Proposition 8. Now it is clear that suppressed evidence may be used for purposes of impeachment should the defendant testify and lie. Anytime they get in the court and they start testifying and acting like something's true, but it's not true, in other words, they misrepresenting facts to the court, you want to impeach them. You want to make them incompetent. You want to let the court know that they are committing perjury, and that everything that they say out of their mouth, once the court is notified that they have committed perjury, is inadmissible as a matter of law. In fact, if I were in there, I would issue an oral motion to hold them in contempt and to investigate every criminal complaint, so-called criminal complaint, that they have ever filed against anybody, for that reason alone. Also, suppressed evidence pursuant to blah blah blah. What is that? PC blah, blah, is admissible at the defendant's probation revocation hearing, unless the officer's actions were egregious. The exclusionary rule does not apply in probation revocation hearings unless the police conduct at issue shocks the conscience. However, inculpatory statements are statements that are tending to show that you are guilty, made by the defendant but suppressed at the product of the defendant's illegal arrest may not be used to impeach other defense witnesses. I'm sorry. Um, y'all need to look. I need to see a whole bunch of email addresses. I should be seeing a whole bunch of email addresses in my email box asking me for this. I'm giving you the game, man. 9 times out of 10, let me rephrase that. 10 out of 10, when you come into contact with the police, it is going to be the Fourth Amendment is going to come into play. 10 times out of 10, the Fourth Amendment is going to come into play, and whatever the Fourth Amendment is under your state constitution, those two supreme laws are going to come into play anytime the police approach you. Anytime. Uh, Expectation of privacy. I'm trying to find, excuse me, the consensual encounters and stuff like that. Okay, we got some habeas corpus stuff on here. I'm gonna read some of that since I think that's relevant. It's apparently on about equal footing with the federal appellate court decisions, it having been held that these opinions are entitled to great weight in the absence of controlling state statute. Okay, well, I'll read that just to let y'all know too. And I'm sure this would probably apply in other states too. I'm gonna start right here. Decisions from other states. California courts are not bound by decisions from other states, although we may consider them absent any direct California case law on issue. Where no California cases have decided the issue presented, we may look to other jurisdictions for guidance. Opinions of the California Attorney General. A published opinion of the California Attorney General is apparently on about equal footing with the federal appellate court decisions, it having been held that these opinions are entitled to great weight in the absence of controlling state statutes and court decisions. Writ of habeas corpus. When a defendant claims to be in actual or constructive custody in violation of the Constitution as a result of the Fourth Amendment, a writ of habeas corpus filed in state blah 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 or federal blah blah blah. Notice that they're citing statutes, y'all. I want y'all to pay attention to this. They are citing statutes. You do not need a statute to petition for a writ of habeas corpus. You don't need that. But notice that that is what they're citing. That is another jurisdiction. That is not common law jurisdiction. There are no statutes in common law jurisdiction. You can use your state constitution or you can use the federal constitution to invoke the court's original jurisdiction to petition a court for a writ of habeas corpus. That is common law jurisdiction. Let's see. You always have to state your right to diversion, which means separate your foreign grantor trust personam from the living man or woman. Um, I think I get what you're saying. I think you're saying not to go in as the legal fiction or so. You just let them know on the record that there's a distinction between a legal person and you. If I think that's what you're saying. I see now why people go to court and tell the judge that they are under an act of Congress. I can see that. Yeah, I can see that. These are legislative courts, man. These are territorial courts. All legislation is territorial. If all legislation is territorial and they are hauling you into their territorial courts for breaching public policy, which is a statute, they're saying that you are within their territory. They're saying that you are a part of their territory. They're saying that they have jurisdiction over you, your person, and they don't. Let's see. District Court of Appeals of Florida talks about an oath of office asking for conviction. Let me go back to reading these cases. When a habeas corpus remedy is sought in federal court, the United States Supreme Court has noted that where the states have provided an opportunity for full and fair litigation of a Fourth Amendment claim, a state prisoner may not be granted federal habeas corpus relief on the ground that evidence obtained in an unconstitutional search or seizure was introduced at trial. I'm gonna get off in about 3 minutes, y'all. Let's see. Here we go, right here. This is what I wanted to talk about. This is what I wanted to talk about. Police citizen context. Context between law enforcement officers and private individuals can be broken down into 3 distinct situations. Consensual encounters. In consensual encounters, the Fourth Amendment probable cause and reasonable suspicion does not apply. The reason they do not apply is because you are not, the police cannot give you any lawful order in the absence of reasonable suspicion or probable cause. They can't give you any lawful order in which that you have to listen to, and if you fail to listen to it, they arrest you for failure to obey or something like that. Consensual encounters are voluntary. That means they require your consent. And you can terminate them even after giving your consent when you want to. Detentions, I don't even know why they have detentions right here. I see why they have arrest right here. A detention is arrest. A traffic stop is an arrest. Anytime that you are not free to leave, then as a matter of law, you are arrested. You are arrested. Let's see. Consensual encounters. Contrary to a non-uncommonly held belief that law enforcement contacts with private citizens require some articulable reason to be lawful, it is a general rule that any peace officer, notice they say peace officer, that's a sheriff, that is not a police officer. But anyway, may approach and contact any person in public or anywhere else the officer has a legal right to be and engage that person in conversation without necessarily having to justify such contact, because that is a consensual encounter. No probable cause or even reasonable suspicion is needed. The law does not prohibit an officer from approaching any person, notice they say it just person, in a public place and engaging that person in uncoerced conversation. Notice they say uncoerced conversation. Law enforcement officers do not violate the Fourth Amendment by merely approaching an individual on the street or in another public place by asking him if he is willing to answer some questions, or by putting questions to him if the person is willing to listen. Willing, consent, he's consenting. But y'all want to get up, but people want to get on here. They want to call people crazy because people say they don't consent to going to jail. They don't consent to talking to police. They don't consent to nothing. You can consent to going to jail. They cannot take you to jail without your consent. They are enforcing public policy on you. That's corporate policy that they are enforcing on you because they are corporations. And I'm convinced that these statutes are in fact bylaws. Matter of fact, I did a video on it saying, I think it's called the Corporation's Constitution or something like that. It's on my YouTube channel. And in this video, they are there's a corporation that is forming, they made a constitution. This constitution looks just like any other constitution, but they're calling the articles within the constitution bylaws. It does not become a detention merely because an officer approaches an individual on the street and asks him a few questions. This is why you need to read cases so you can know your rights. This is why I sued the police in my case, because my car broke down. I'm a stranded motorist. You have no lawful purpose to ascertain my name. And I have every right not to tell you my name if I want to. I don't care if you think I got something to hide. If I don't want to tell you my name, I don't want to tell you my name. And you need to just get over that. Go back and check this, man. I need to get off here, y'all. I need to get off here. Is this? Would y'all like me to go over this document again from time to time? They've copyright. They've copyright written all their statutes as a means to contract with unknowing private individuals. It wouldn't surprise me if they did. I'm not saying you right or wrong. I don't know, but it wouldn't surprise me. None of this stuff. Don't none of this stuff surprise me, man. Nothing. Ugh. All right, y'all. I'm gonna end this live, y'all. 2 hours. I think 2 hours is enough of my time. It's pretty good. I'm tired anyway, so I'm gonna go ahead and get on off of here. And before I go, is this something that y'all would like for me to continue to do in regards to this document? Would y'all want me to keep reading this document from time to time? Because I think y'all need to read it y'all self. But if y'all want me to read it, you know, I'll do it from time to time. I'll go through it. Close this. Whew, boy, tired, y'all. Tired, tired, tired. All right. If you haven't hit that like button already, go ahead and hit that like button. Stop being stingy. Stop being stingy. All you got to do is, that's all you got to do. Just tap that button. That's it. Let me turn this off. Go back, turn the camera on. Yeah, man. That's all you got to do. Stop being stingy, y'all. Hit that like button. Okay, y'all. I'm tired. I'm mentally exhausted. I'm going to go in here and get in the bed or something. And I'm going to relax. Hopefully this y'all got some education out of this video. Oh, bench book for judges and federal rules of civil procedure. Support. What do you mean, bench book for judges and rules of federal civil procedure? What do you mean? That'll be the last question I take for the night, y'all. I'm tired. Ooh, I got a headache. That's episode 7. Okay, so I have to on your next live, if possible, go over. I don't have I don't have copies of the bench book for judges. I don't have that. All right, y'all. Everybody enjoy your Sunday evening. I'm gonna get on out of here. Thank y'all for y'all time. And the supreme litigant is out. Peace. Man.